And one of the things that Mariam picks up on is the arbitrary nature of Sharia law. On this anniversary of the Declaration of Universal Human Rights, we have to ask ourselves as a country whether or not we do believe in universal human rights, or whether we believe actually that it's all relative and that we can apply some kind of cultural relativism and so allow a minority group in our society to apply different rules to the people in that group. As Mariam said, the aim of this campaign is the protection of the rights of women, children and minority groups. The campaign states that Sharia law doesn't accord with the principles of equality enshrined in UK law. The use of religious law in family law proceedings would deprive women of their rights that are available to them in civil courts, and there's a serious issue as to whether or not women's consent would actually be freely given. Whilst we accept that religious freedom is a private affair, also the rights need to be protected that are fundamental human rights of the people in those minority groups. So toleration and accommodation of minority groups who seek to engage in alternative dispute resolution must be balanced against a firm commitment to individual autonomy and principles of justice, fairness and equality for all. The fundamental tension that must be addressed is between respect for minority group and protection of a person's individual rights within that minority. So if the state allows cultural and religious groups complete freedom to define family and inheritance matters, those groups may trample on the rights of individuals within the group in a way, and discriminate against them in ways that are unacceptable to British society. So cultural and religious groups must not be permitted to stop people having access to laws and processes that are available to everybody. I want to talk about two things. Firstly, about Muslim arbitration tribunals, and secondly, about Muslim councils. There's a lot of misinformation in the press about Islamic courts in the UK. In the UK, Muslim arbitration tribunals have been established since 1997 and are holding themselves out currently as providing services in family law matters such as divorce and the residence of children. Whilst it's accepted that parties can legitimately agree to arbitrate civil disputes such as a contractual debt using religious principles under the Arbitration Act 1996, family law matters cannot be the subject of contractually binding arbitration agreements, and this has been the case at law for a long time. These courts do not seem to recognise that. The jurisdiction of family courts to decide matters relating to family, to do with children, cannot be ousted by contractual agreement. So, as I was just talking to Gina earlier, an example she had of a woman who had had to sign away her family law rights in UK courts in order to get an Islamic divorce. That actually wouldn't be legally binding, and if she went to a UK court, she could still get her rights. But the problem is that people simply don't know this on the ground. The Minister of Justice, Jack Straw, speaking in November, also confirmed this when he said, arbitration is not a system of dispute resolution that may be used in family cases. There's no draft consent orders embodying the terms of an agreement reached by the use of a Sharia council. Sorry, there's no situation when an agreement reached by a Sharia council could have been enforced within the meaning of the Arbitration Act in matrimonial proceedings. Therefore, the decisions of these courts, the Muslim arbitration tribunals, are not legally binding and they're not enforceable in UK courts. Even if they were enforceable, UK courts cannot enforce any arbitration agreement which is either contrary to public policy or contrary to UK law. Therefore, an inheritance dispute, which could technically be the subject of a civil arbitration because it's not a family matter under the family courts, an unequal division of an estate giving more to male children than female children would not be upheld by UK courts. The One Law for All campaign believes that religious tribunals are holding themselves out and persuading women in these communities that their decisions are binding. Therefore, not only do we need to target our campaign to outlaw the use of such courts, but also to inform women of their rights in the UK courts. There are a number of issues where Sharia law does conflict with UK law, such as I've said, the unequal division of estates, the custody of children, the maintenance that a woman is entitled to on divorce. Obviously, the evidence of women is not held in the same status as men, and also the issue of polygamy. All of these issues, if they were arbitrated, would not be enforced by UK courts. In terms of Sharia councils, these are bodies which give religious rulings or fatwas and also deal with religious divorces. The legal campaign acknowledges that although public bodies are not caught by the Human Rights Act, if they hold themselves out as offering these arbitrations, they must be stopped from doing this by a change in the legislation. The problem in terms of protecting women's rights is that many women believe they're not divorced, or they are divorced according to what these councils are telling them, and that they are in fact unaware of their legal right. The information campaign will be used to inform them of their rights, and the proposed legislative amendment would catch Sharia councils if they attempted to make their decisions binding, or even purported to tell people that their decisions were binding. One of the objectives of this campaign is to gather evidence to make sure that we come up with the correct legal solution to this problem. In conclusion, the One Law for All campaign aims to protect the rights of vulnerable women, and whilst it's the case that existing UK law would not permit religious family law decisions to be enforced, the main problem is that many women do not know this fact and believe that the decisions are binding, or are reluctant to challenge those decisions. So legislative reform is needed, urgently needed, to protect these women in these minority groups and to make sure that they not only know of their entitlement, but also use their entitlement and access the public courts that are available to everybody. What the Muslim arbitration tribunals have tried to do is to use the Arbitration Act 1996, which says that if you comply with a set number of criteria and both parties consent to the process, any agreement that results from that process is actually binding, and therefore you can go to a UK court and get the bailiffs to enforce the debt or whatever it is. Actually, in family law, you can't do that. But what they're doing is they're saying once the woman's submitted to this process and potentially signed away her family law rights, that's final, and she doesn't actually have access to the courts. Well, unfortunately, we don't live in a secular state. We've got an established church at the moment, but
it should be separate to state.
Well, the status of these tribunals has no foundation in law. And you and I could decide to pick some person off the street and go and arbitrate tomorrow and create a legally binding arbitration agreement. Whether or not that would be upheld in a court of law would depend on whether we'd complied with the strict terms of the Arbitration Act. It's not the case that you can exclude the use of the courts unless you've complied with those decisions. But as I said, you can't exclude anyway in family cases. We don't need to amend the Arbitration Act because the Arbitration Act at the moment permits civil arbitration, but it's a separate piece of law that outlaws its use in family law proceedings. So the reason that we need to actually outlaw the use of arbitration by creation of a criminal sanction is because if you just make it illegal, so if you don't make it illegal, there's no way to enforce it and stop people actually doing it. Because at the moment, everyone knows it. Well, lawyers know it's illegal. The Minister of Justice knows it's illegal. But people are still holding themselves out as doing it. So we've got to find a way of stopping them. And a criminal sanctions the only way to do that, or some other financial penalty, but that would be a separate piece of law.